So without further ado, rather than having sort of a long build-up into this session, what I would like to do instead is immediately turn to Maria Arena to give us a little bit of the context. So we've been seeing a growing attention internationally to the need to address the lack of accountability for the actions of corporate subsidiaries, as well as the adverse impacts, addressing the adverse impacts of companies operating through global value chains. We heard the example of Rana Plaza earlier. The UN Guiding Principles on Business and Human Rights talk about the need for a smart mix of measures, meaning both voluntary as well as hard law. And we also talk a lot about that at the EU level. Given that discussion about the smart mix, why do you see a need for regulation for hard law?
I will speak in French. So, tout d'abord, merci.
First of all, thank you for organising this meeting. I don't think we can stay in this existing situation in the present situation, because we've been living globalization for some time. Globalization which can bring us positive things, and we can see today that world trade turns around this division in production throughout the world. It's a reality, and Europe is an important player in this global value chain. But once we know that Europe is an important player and a beneficiary, and both could be suffer collateral damage, I think that Europe needs to take a certain number of initiatives. What type of initiative? Well, we can see today that there is a tendency, and I know that there are representatives from the European Commission here today, there is a tendency, when it's a question of talking about protecting investments, we have hard law measures which are extremely restricting, both for states and for European legislation. We really have, therefore, an attitude which is law, rules, regulatory, private courts, arbitration and so on. So they're very tough as far as investment is concerned. But when it's a question of human rights, and in particular human rights which are outside the European space, because we're in the European area, we have pressure on human rights which can come from society. Today there's the Etique trial which is taking place today in Brussels. We needed time, of course, to recognise the Etique company for being responsible for cancers in its the way it worked in its production. But when it's a question of human rights and respecting health in Europe, you can go for hard law. We're working on the cancer guidelines in the workplace. That's hard law. But when it's a question of being outside the European space, we have a tendency to opt for voluntary measures. And when I was responsible for I was the rapporteur for the file on minerals and conflicts, I always said it's strange if this telephone, if it had a negative effect on the health of Europeans, we would immediately have taken measures, hard law measures, to protect the health of Europeans. And that's what happened when there was the mad cow disease business about being able to trace back through health systems and the food chain. On the other hand, this telephone, which kills human beings throughout the world, we haven't managed to get hard law in place, because they're not Europeans, they are Africans who are dying, South Americans. And we had this difficulty when we worked on the law on minerals and conflict, and the initial proposal of the Commission, well, there's a proposal obviously in the textile area, for example. We still don't have any legislative proposals, so I would like to Rana Plaza provokes the same empathy from the Commission as it did for minerals conflicts with all the Africans who died and the people who died because of these minerals. I would like it to lead to the same legislative approach, because this legislation can only be taken by the Commission or Member States. But we have the same resistance, come up against the same resistance today. There's an initiative, but it's voluntary. And if we have managed to have something, and I know that civil society isn't satisfied, neither am I have to say, with what we've obtained, then obligatory, but only on over part of the production chain. If we manage to get that, it's because civil societies, national and international civil societies, have mobilised to support us in this approach and help us to go a little bit further. Just a little bit, something else that I wanted to add. I often hear companies, member states, the Commission say, you have to empower the consumer. That's to say, he has to be accountable. He has to make enlightened choices. He has to make choices. I agree that the consumer has to be informed, obviously. And, of course, you need as much information as possible for the consumer. But it's not at all appropriate to put all the responsibility of the cleanliness of the value chain on the side of the consumer. These value chains are so complex that it's not possible for the consumer to exert his responsibility. And to those who say, but the consumer will settle everything out through over the market, because if you believe in the theory of the market which is going to solve everything, well, I don't think so, because quite simply he will never be able to have all the information he needs on the cleanliness of this value chain. So as I see it, you have to put the responsibility on the side of those who have the means to deal with it. That's to say multinationals, who today are responsible for more than 50% of production in these value chains. So I think the multinationals have more, they have more possibilities to make these value chains clean.
Bon, merci beaucoup pour ce propos très juste. Venir encore vers vous.
Thank you very much. This is right, and I will come back to you a bit later to discuss the next steps on the European level. Now I'd like to turn to Mr. Potier to talk about the French level. So you work in France and you've seen that regulation was needed. How did you come to this conclusion? Thank you very much for inviting me and for this great initiative at the European level. A few days after the French decision by the Constitutional Court that validated the principle of the duty of vigilance law on parent companies and their subsidiaries. So before I answer precisely to your question, please let me recall that we are now in Europe going through movements in our societies, in our countries, nationalist movements, and there is an absolute necessity to show that Europe can have a new face and can renew its action. And we have here an extraordinary political opportunity. So through some people are afraid to go to go this road today, and this would be a danger. We have to be guided by humanism, and that's how we can find a new ideal for Europe, which is in danger today. And there are two deep movements today. First, we should not consider that companies are political actors. They are. It's actually part of the company's responsibility to have a political role to play. That's a political revolution. But it's absolutely necessary. According to me, companies are political organizations, and they have to participate in general interest in their own dynamics. Company law has been founded in the 18th century. But now we have to make sure that company law is not becoming the instrument of the new bullies of our era and doesn't turn against citizens. As Maria Arena just said, we have to build a new generation of rights. Some people would say we need world governance, but we don't have time for that. We don't have time for the environmental responsibility of companies to build itself. And we've seen that after a few years, we have only a few % of increase of results for the European and French companies. We don't have one more century to reach good results, and it's the same for world governance. It's moving forward on climate, on financing with the new laws and new regulations. And in France, we've had this new idea to make sure that companies are obliged to put in place due diligence in the sense of general interest. And that's something that's really new in regulation overall. So as some people have written, the sovereignty has to be part of the nation, of the states, but it has to impose an obligation on companies which are part of those states to apply the same rules all over the world in the name of humanity. So there's a very positive dynamics that's been started on child labor in the United States, on traceability of in Spain or in the United States too. Those are very great efforts which were there before the French law. But I think the French law we're talking about is really new in the sense that it will impose on companies by themselves to contribute to general interest, and which will allow us to make sure that they put everything in place to prevent damaging effects before they occur.
So on the other hand, it is actually a legal means by which the state can, on the one hand, ensure that the business is actually living up to certain expectations of society, and on the other hand, that judiciary and regulatory authorities can actually assess whether a company has really lived up to the standards. So, and this concept is known for a long time, so long before the UNGBs were ever drafted. Actually, a study in 2012 looked into the legal systems of about 20 countries and found more than 100 examples of due diligence in the legal context in different legal systems, be it criminal law, be it civil law, be it administrative law. And there it also has a lot of different models I can maybe discuss later. And what is interesting also, it is the recognition of due diligence as a steering tool or as a regulatory tool. So that's also the reason why in the international context we see due diligence more and more promoted as a tool. So you see it in the Council recommendations, Council of Europe recommendations that Jérôme mentioned before. At the OECD, many standards are developed around due diligence, and obviously also at the UN level.
Thank you very much, Nele. And as you say, we'll get into a little bit more detail about how this has been embedded in law in just a couple minutes. But Margaret has been working on the Corporate Human Rights Benchmark, which is a very recently publicized tool that attempts to sort of rank corporate behavior against these human rights. Do you mind telling us a little bit about how it works?
Okay, thank you, Paige, and thank you to ECCJ for the invitation on behalf of the human rights organizations and investors that are behind the benchmark. There we go. Okay, good. We'll start with that one. So, thinking about this issue of a smart mix of measures, these 8 organizations came together to think about, to answer the question, can we use market forces as well to improve corporate human rights performance? And we did that by actually creating competition among companies by ranking them. So this pilot project ranks 100, well, it's 98 by the time we finish the year, 98 of the largest companies in 3 sectors. The benchmark also seeks to provide a more systematic and, in fact, a more scientific way of looking at what companies are doing on human rights. So it really has those 2 objectives of creating market forces, creating competition, and being more systematic and more scientific. So looking at the 100 biggest companies in these 3 sectors, it looks across the areas of the UN guiding principles. I don't know if you can quite see it there, but it tracks the UN guiding principles, plus adds sections on performance, and also looking at how companies are dealing with serious allegations of human rights abuse. I could spend hours talking about the results of the benchmark as we did when we launched it, but I think I only have 1 more minute, so I'm just going to talk about what we found out from this first pilot survey on human rights due diligence, if you want to go to the next. So of the different parts of the benchmark where we're looking at what companies are doing, and that information is taken almost exclusively from public information from companies' own sources, so what they're saying. With the exception of the serious allegation piece, we look at what companies are saying about themselves. So human rights due diligence, as you can see, is 15% of the overall score, and there's a whole series of questions looking about how companies set up their system and how they process this through their systems, with some examples. So very quickly, the results on the next page. You want to go to the next slide on human rights due diligence. 3 particular messages that we noted from the research and the benchmarking that we've done. One is that there are only a small cluster of leading companies that are really doing this on human rights due diligence on a systematic basis. A bit not surprisingly, companies tend to be stronger on the identification and the assessment, and performance drops away as you get into the other parts of the human rights due diligence process, which is integrating and acting. That's the prevention and mitigation, tracking, and communication. And finally, that so that's, in fact, on the communication is particularly the weakest issue. You'll see the overall scores in each sector. I don't know, if you can read it, for the due diligence processes. And what that shows is that there are some leaders, but on the average, the scores are very low. So there's a long way to go on these issues. The good point about having leaders is it shows the way, that it shows that it is possible for companies to do this. But as I said, for many companies, there's a long way to go. The hope is that this benchmark results gets picked up not only by companies, but also by certainly civil society, but also by government and legislators as an evidence base. Thank you.